Welcome to the class tonight. Thank you very much for joining us. The topic we're going to discuss is board member boundaries and obligations. Now that you're on a board or you're serving on a board, what do you do? What can you do? What do you have to do? Is kind of the gist of what we're going to go over tonight. And it's then how you do it is really kind of document specific, up to your documents and state law. But we're going to go through how far or what, as I mentioned, what you're required to do, and then how far or how much authority do you have to kind of act outside of maybe what's specifically printed in your governing documents. Because I know every one of you has a situation that comes up, I will say, on a daily basis that's not specifically addressed in your declaration or in your bylaws. And that's where you kind of look and say, okay, where do we go? How do we go? What can we do? So, where do these duties come from? Your duties come from Colorado law. Excellent. That would be the Colorado Common Interest Ownership Act, the Colorado Revised Nonprofit Corporation Act, parts of the insurance statutes dip into Colorado Common Interest Ownership Act. Other parts of the real property statutes dip into the Colorado Common Interest Ownership Act, such as the restriction on the prohibition on restricting solar panels. That's actually found in a different section of the Real Property Act. It is not in the Colorado Common Interest Ownership Act. There are revisions to the statute that are being proposed and run through the legislature right now that are going to appear in various different areas of the statute books. So it's not all just one statute or two statutes, but these are the primary ones. It also comes in your declaration, your articles of incorporation, and your bylaws. Those are your governing documents. And everything you do has to at least be grounded in either Colorado law or those documents. So, what is does anybody know what the difference between a duty and a power is? Anybody?
A duty is something you have to do. A power is something you can do.
Exactly. Way to read. No, I like it. A duty is something you are specifically obligated to do. You have to do it. And if you are not doing it, it is a breach of your fiduciary duty to the association. It is actually actionable by the owners if they so chose to take action against the association for something. And usually where you see it is collections. You are a community association. These are your neighbors. These are your friends. And in some instances, you have to collect assessments. You're required to do it. Your declaration and Colorado law says you shall collect assessments. You have to establish a budget, and if people don't pay, you actually have to take steps to collect those assessments from those owners that aren't remitting assessments to the association. A power, on the other hand, is discretionary. You can do it, such as adopting rules and regulations. You can adopt parking restrictions, you can adopt dog restrictions, you can adopt, you name it. However, once you do that, you must enforce your rules that as they are adopted. So it's we're going to go through the powers and duties, how they layer into your obligations, and then again, the boundaries, how far can you push that? Or if you want to push it, or how conservative can you be, knowing that you may want to be conservative and not necessarily go out and do things that you can't or want to do. All right. As we mentioned, the statutory framework, getting more into it, is the Colorado Common Interest Ownership Act. And we're going to work through these statutory frameworks and the Nonprofit Act. That actually is the Nonprofit Act, not the In-Profit Act. But as I had mentioned to a few of you, I've been on jury duty all week, so trying to proof this on my phone makes it really difficult. So that's nonprofit, not in-profit. Okay. One of your first duties as an association is you must have meetings. It's required by your articles of incorporation. How to do it is set forth in your bylaws. And it is part of your fiduciary duty as set forth by statute to have regular meetings. You can't properly govern an association if you're not meeting, if you're not discussing association business, and if you are not determining how best to act on behalf of the association. A failure to meet would be a breach of that duty, because again, you get into situations where associations, maybe they only want to meet once every 6 months. Well, can an association meet effectively and govern the community once every 6 months? You think? Sometimes. Fair enough. Sometimes you can. You only have annual member meetings. Come on in.
To make sure I'm in the right place. Probably not. Sun Creek Drive, HOA?
No. So yes, you are. Sun Creek Drive? No? This is a class.
Okay, this is a class for the board members.
Yes. So it's how often and how much you have to meet can be a decision of the association. But normally when you're talking about contracts, you're talking about having, if you've got pools to maintain, if you've got roofs to maintain, if you've got insurance to renew. I know there was a conversation about insurance right before the class started. You have to be able to meet and discuss those obligations. And if you're not meeting, again, you're failing to meet that fiduciary obligation. Now, how you can do it is you can meet in person, but Colorado law actually allows you to meet by email. There's a notice requirement to all the board members. If you send out a notice to all the board members and you as a board member tell them exactly what you're going to vote on, when they have to return that vote, and that if they fail to vote, it acts as consent, you can take action outside of a meeting. Now, I will tell you the state legislature is trying harder and harder and harder to preclude you from doing that. And every year they tweak that statute to make it a little bit more difficult. But it is still a right of the association to meet without a meeting. Now, you also have to go through and notice when you meet in person, there's no affirmative duty in the statute to notify the owners that you're meeting. Now, it's sometimes a misconception that Kiowa, the Colorado Common Interest Ownership Act, says every meeting of the board is open to all owners, which is true, it is. But there's still no affirmative duty to go out and notify all the owners that you're meeting. So it's one of those things that it's kind of a trick question. So that's one of those boundaries that if you're trying to meet, you can kind of push a little bit further. And I know a lot of associations, they like to meet in working sessions where there's not going to be actually any decisions made, but they do want to get together and talk about the budget, talk about X, Y, and Z. Those are still meetings, and if owners want to come, they have to be allowed to come. But again, it's one of those things that you can move forward with.
But they're not, you don't have to tell them it's a meeting and they can meet in 5 minutes.
Well,
In 5 minutes.
Good question. The question was, you don't have to tell, who do you have to tell, or who do you have to tell your meeting, and you don't have to tell the owners. No, you don't have to tell the owners. However, at the same time, your bylaws are going to contain a minimum meeting notice requirement, usually 24 hours, maybe 3 days, up to 3 days. The statute leaves it blank. You can, whatever your bylaws say is how often or how much notice you have to give. However, that being said, kind of going to that boundary of what you can do, if all of your owners did want to meet, or not all of your owners, I'm sorry, if all of your board members did want to meet on shorter notice, they can all waive notice and attend. So you could call them up and say, look, we've got something that's happening and we need to meet in 5 minutes. Let's all go to Starbucks. You all can meet at Starbucks, and the first order of business would be, does everybody waive proper notice of the meeting? And you put that right on the meeting minutes. An emergency meeting was called and proper notice was waived. Yes. But that being said, if somebody calls up and says, I don't waive notice, you can't have the meeting. So, any questions on your duty to provide notice? Yes?
Is there a specific guideline if there's some business needs to be performed regarding a homeowner that it could be closed, or is everything legislative?
The question is, when can you close a meeting? And it is statutorily driven when you can close a meeting. There are about 6 different reasons where you can close a meeting. It's such as when you're talking about attorney-client privilege communication, when you're discussing when your attorney is actually at the meeting, you can close it and go into an executive session. When you're discussing manager performance, manager compensation, or employee performance, employee compensation, or discipline, you can go in an executive session. Or the general kind of a catch-all, anything that would be an unwarranted breach of privacy as provided for in the Constitution. It's kind of this big overarching catch-all. And I've had a discussion with a couple of you as to when exactly can you go into an executive session, because I know some associations like to go into an executive session when they're negotiating a contract or trying to negotiate with owners for certain things, and it really doesn't fit in a perfect place as to going into an executive session. But there are statutorily stated reasons to go, not just homeowner complaints or violations. Yes, sir.
What about if you're discussing delinquencies?
If you're discussing delinquencies, technically, that does not fall into one of the exceptions. So it should be done in an open meeting. Now, I'm going to tell you, don't use names when you discuss delinquencies. When you discuss delinquencies, you really should be putting on like a line item on a report. Line item 17, this owner is 6 months delinquent, we're going to take this action. Because I don't want you necessarily going through and saying, homeowner XYZ is a jerk and we really need to go get him. Not saying that you would say he's a jerk, but it's use more of the identifiers as opposed to the names. Like the unit number. Now, if an owner comes to you and comes to the board and says, I have a reason I'm delinquent, and I'd really like to discuss it with you in private. You could probably go into an executive session for that, because that would become, in the owner's eyes, an unreasonable invasion of their privacy. Because it could be something along the lines of, I am unemployed, I'm about to file bankruptcy, I'm about to do this, I'm about to do that, it's highly personal because of X, Y, and Z. Then you might be able to justify going into an executive session. And it really is, if the owner comes to you, you as an association can't just require it, or can't just go into executive session without the owner saying, yeah, it's personal.
Wouldn't using the unit number be just as bad as using their name? I mean, everybody knows who lives there.
Question is, wouldn't using the unit number be the same? And yes, it is in some instance. What we're trying to get away from is the personal, putting the name to it, because, again, it's just best practices. There's nothing to say that you can't use the name. It's just we're trying to get away from it, because you don't want that owner to come out and say, you know what, they just accused me of being delinquent and they're wrong and they published my name and they did this and they did that and they embarrassed me and now I'm going to sue them for libel. If you use the unit number, you didn't do that. You just said unit number X is delinquent.
You choose to still discuss delinquencies in closed or in executive session. You eliminate that.
The question is, could you choose to still discuss delinquencies in closed session? And I'm telling you, it's risky. And without some sort of, like I said, request from the owners, it's risky. The way, again, the legislature's really pushing associations to more transparency. And they want everything done in open meetings. And they want everything done with as much on the record as possible. So that's kind of why I'm saying, it's risky. I know associations have done it, and I know associations continue to do it. I'm just telling you, the way the legislature's moving, it's going to get you in trouble someday.
And don't the other owners have a right to know why the budget isn't totally balanced?
Of course they do.
Where
And
the money is coming from and not coming from?
the question is, don't the owners have the right to know where exactly the funds of the association are and where they aren't and where the money's coming in? And of course they do. And every owner has the right to come in and inspect the association's records, which includes detailed accounts of receipts and expenditures, and they can see exactly who's delinquent and who's not delinquent. It's that verbal publication at a meeting that we're trying to avoid. Because yes, sir.
In meeting minutes,
Mhm.
one thing, we never put personal information in meeting minutes. We'll put quantities of people.
Okay.
And things like that as far as delinquencies, but we don't put addresses and names
Good.
like that. I would assume that's still okay to do that.
That is fine. The question is, on your meeting minutes, you're not putting addresses, you're not putting names. Is that acceptable? And that is, of course, acceptable. You can just say, we have this much in delinquencies, this much 30 days, this much 60 days, or however you're doing it. Again, as long as you're not identifying. Mhm. Absolutely. Okay.
David?
Yes. Mhm.
or a meeting with the board and nothing is voted on? You have to do minutes for it?
You know, the question is, do you have to take meeting minutes if nothing is voted on? And I will tell you, generally speaking, first, if you have a meeting, and it is a meeting, yes, you have to have minutes. Now, what is in those minutes, it becomes up to the association and how they take meeting minutes. I have written articles, and I've opined that, you know, meeting minutes should really just be action items anyway. It should be the board, the meeting opened, the board discussed painting contractor X, the board approved painting contractor X by a motion of 3-2. We're going to sign that contract. Don't put in the meeting minutes the back and forth debate or the reasoning necessarily behind it. I mean, if you want to put in the meeting minutes that painting contractor X has a great reputation and can mobilize faster than contractor Y, and that's why you did it, that's great. But you don't necessarily have to put that in there. The meeting minutes, the reason you take meeting minutes is for two reasons. One, it's historical information to the association. When somebody comes in 6 months, 8 months, 10 months down the road, or 5 years down the road, and they want to know when you painted last and how much it costs so they know if they're getting a good bid, or the colors you used, that's where they're going to find it in the meeting minutes. It also, the meeting minutes have a presumption of accuracy. And if you go to court for whatever reason and they pull your meeting minutes, and I'll tell you, the place this pops up the most is in the event of a CCRD complaint, a Colorado Civil Rights Division complaint. Somebody says you're discriminating against them. And it'll most likely come up because you told them they couldn't have a dog or a cat or you name it. And they sue. Then the CCRD, the Colorado Civil Rights Commission or Division, is going to ask for every one of your meeting minutes. And they're going to want to know how often you discussed it, how you treated other cats, how you treated this, and those meeting minutes have a presumption of accuracy. And we want to keep it that way. So as long as you're putting minimal amounts of information or bullet-pointed information, the better chance you have of keeping that presumption of accuracy in place. So if you have a meeting and you still discuss topics, even if nothing is voted on, you should still say the topic was tabled. We discussed painting contractors, topic tabled, but you still have a meeting because you still have minutes because you had a meeting. Any other questions on that? Well, thank you very much. That was great. Okay. Standards of conduct. So we've talked about your meetings, and we've talked about what you have to do. Now, getting into, you've got standards of conduct. You have to act in good faith. The law requires that you subserviate your needs to the needs of the association, and you act in the best interest of the association in good faith. You can't have, you know, I hate to define a topic with just the reverse, but you can't have bad intentions when you get into your meetings. You can't get in with the intent of, I'm going to get this guy, so he's my neighbor and his dog barks, and I'm going to adopt a rule specifically with the intent of banning dogs. That's not pure motives. That's not good faith. You can't just go down that path of, I say personal vengeance, but you do need to make sure that whatever you're doing applies to the whole association and it benefits the whole association. With the care and ordinarily prudent person in a like position would exercise. When you're negotiating, let's say you're negotiating a contract and you get 3 bids. 2 bids are for $10,000, give or take, and 1 for $4,000. And you're looking at this going, you know, I really like that $4,000 contract, and you look at the contract and it says they're just going to come in and they're going to do this, this, and this, and have absolutely no safety standards, and the person doing it's not insured, and they they come in a beat-up old rickety truck that is falling apart, and all their equipment looks like it's falling apart. And they're not going to tape. That was one of the savings. They're not going to tape the buildings. Okay? Would a reasonably prudent person approve that type of contract? So it's that kind of, sometimes the best deal isn't the best deal really. And you as board members have a duty to figure that out and to vet these contracts and ferret out these details to see exactly what would a reasonably prudent person do in a like situation. Investment in reserve funds is another wonderful example. Is when associations go in and they've got their reserve funds and they're looking at where to put it. And you can either put it in an FDIC insured account or you can give it to Lou down the street and who's guaranteeing you 300% in the next 30 days. What would a reasonably prudent person do? So that's, you've got to ask yourself that. The best interest of the association, and you have to rely on the, yes, sir.
On that particular topic specifically, when you say a reasonably prudent person, and, like you used an example that obviously we would choose the FDIC insured account.
Right.
It seems to me that no homeowner association that I've ever been a part of or seen or lived in will do anything other than an FDIC insured account. But having been an investment advisor, I've seen investment advisors get sued for giving too conservative of advice. And so I wonder, does that apply to HOAs? Like, we're not going to lose money no matter what. Well, we're actually losing money to inflation slowly and safely.
And
so I wonder if we should be more aggressive
Okay.
and like a responsible.
the question was, is the association potentially exposed to liability for being too conservative, given that a reasonably prudent person may invest their personal funds a little bit more aggressively because they're not making but 0.0006% on a savings account and an FDIC insured account? The answer is I have actually seen associations get a little bit more aggressive. I have seen some associations, for that very reason, they have larger chunks of money and they're kind of looking at this going, we can earn 1%, 2%, 3% by putting it here. May not be FDIC insured, but it's still government backed. It's still this, it still has some of those securities, and the money really isn't at risk. You can be a little bit more aggressive. You as an association are required, kind of one of those duties, to adopt an investment of reserves fund policy. And as long as you're investing in accordance with that policy, and the policy is the same, set to that standard of a reasonably prudent person, you can get a little bit more aggressive. But again, you've got to remember this isn't your money. This is a nonprofit corporation's money. And what you may do, the risk you may personally be willing to take is not necessarily the risk the association should be taking. But I have not, let's put it this way, I have not seen lawsuits of being too aggressive or too non-aggressive, where I have seen associations get in trouble being a little bit too aggressive. So it's still the reasonably prudent person in the context of managing somebody else's money. Yes, ma'am.
So you mentioned the investment of reserve policy.
Yes.
Is that one of the 9 Kiowa?
That is one of the 9 SB 100 good governance policies. Yes, it is. And the question was, is the investment of reserves policy one of the required policies? And it is. Okay. So and getting back to relying on information and opinions, one of the reasons you want to do this and you've got this duty to do that is this wonderful aspect of the business judgment rule. And the business judgment rule states that so long as you are acting in good faith with the care of an ordinarily prudent person, you get the benefit of the business judgment rule, which says even if your decision turns out to be wrong, you still are not held liable for anything that may become of that decision. So in answer to your question of the reserves, if you go out and you talk to many different investment reserve people, and you go out and talk to some investment advisors, and you go talk to your association attorney, and you go talk to your tax guy, and you come up with a little bit more aggressive strategy, even if that aggressive strategy loses the association money, the association and you as directors are not held liable for that loss because you acted in good faith in the best interest of the association like a reasonably prudent person. It's a wonderful, wonderful concept. Okay.
Just a question.
Yes.
Would that somehow affect the directors' insurance? That somebody gets a little more aggressive and says, well, if I do some mistake, nobody can get me.
It's the question is, does that kind of impact everything moving forward? Because if you know that you're covered by the business judgment rule, if you know there's no personal liability, can you get a little bit more aggressive? And again, it's as long as you're listening to the advice of your professionals, because you're all volunteers, and you don't have specific education in many of these topics. Nobody could. You are running a small nonprofit corporation, and it's a business, guys, and it needs to be treated as such. So I guess in answer to your question, you know, just because you have this shield, you still have to act in all those ways. So you also, getting back to, you have a duty, every director has a duty to disclose any potential conflict of interest that it may have. Now, conflict of interest is statutorily defined. It's not whether you enter into painting contract and you decide to paint your building first. It's not a situation in that you are, let me see, a situation where, oh, you want to adopt a rule for parking and there's parking problems in front of your unit. That's not the kind of conflict that the statute addresses. What this conflict of interest means is if you as a director or anybody in your family benefits financially from a contract or action of the association, you must disclose it. You have to have a policy on it of how you are going to treat it. So you've got a duty as directors to disclose any potential conflicts of interest that you may have. And again, that is just when you're contracting with the association, if you own a lawn mowing company and you bid for the landscaping bid. If your brother owns a painting company and you're putting it to bid out to painting, you must disclose that conflict. So it is a duty, and the statute states that once the conflict's disclosed, you can actually listen to the debate, you can participate in the debate, you can even vote on the matter if you want, or if the association's policy says you can. Now, the association's policy is going to state some of those ability of the board to preclude you from voting if the policy states that a conflicted director shall not participate in the discussion and shall recuse himself from the vote. But that's policy driven, not statute driven. Yes, ma'am.
How do you notify of a conflict of interest? To the homeowners, I take it?
Sort of, yes. And the question is, how do you notify the conflict? The statute says that you must get up in front of a meeting of the board of directors on the record and say, I, David, have a conflict of interest. And then it's done. And of course, you need to say, I have a conflict of interest because my brother owns the painting company, and then it's done. And then you can make those decisions. You pull out the policy, and you say, okay, in this situation, what do we have to do? Do we have to recuse ourselves? Do we have to leave the room? What do we have to do? Any other questions on that? Yes, ma'am.
Can I give you a situation and ask you if it would be considered a conflict of interest?
Please do.
If the homeowners association has a management company that
Mhm.
owns, say, a landscaping company,
Okay.
as an example, and that management company is putting out a bid for
Mhm.
landscaping, and their landscaping company that they own bids on that contract,
Right.
is that a conflict of interest?
The question is, what if your management company has the conflict? If the management company owns a landscaping company, and you are bidding out landscaping contracts, and the management company, of course, sends themselves a bid. Yes, that is a conflict. The management company, and this is how, it's the statute goes into, says each board member must. But when you get into that, the manager is acting as your agent, and as your agent, they are going to fall subject to these same requirements. They have to act in good faith.
This applies also if the board member has stake in that company.
Yes, if the board member has a stake in the company, that specifically, that board member has to get up and notify the association, or the board. I see why you're confused. Yes, sir.
Could you elaborate a little bit on that last word, no transactions, got several boards that were what about?
And that was getting kind of where we were starting to go. If the disclosure is made and the contract is inherently fair, the legislature decided that they're not going to touch that contract. It was done at an arm's length transaction with both parties' eyes open, or they knew what they were getting into. So you cannot, just because a contract involved a conflicted director, void that contract. It has to be inherently unfair to the association or not an arm's length transaction. So, and then we skipped over, the association does not have the authority, power, and in no circumstances at all to loan anybody money. The association should not be loaning directors money, shouldn't be loaning owners money. Just no, that's bad. So we'll leave that one alone after that. All right, what's next? Okay, so we get into the conflict must be disclosed, and it defines, the statute defines the parties that are related to the director, and again, it's anybody that's related to the director. Husband, wife, sister, brother, significant other. If you're a close relation to any director, it's a conflicted transaction. And you really need to make sure that that's, again, noted on the record. Okay. So, closing that down, we go on to powers of the unit owner association. So, the powers of the association, you have these powers discretionary as to levels without specific authorization in the declaration. You've got the power to impose late charges and attorney's fees, to impose fines after notice and an opportunity for a hearing, critical. You cannot apply a fine to an owner's account until after you have given notice and an opportunity for a hearing. Does not mean you have to have the hearing. It's incumbent upon the owner to request it. It is incumbent upon the owner to show up at the hearing. But if they do, you have to have the hearing. And getting back to anybody's fine letters, if you send out a fine letter and it says a $50 fine has been added to your account, but you have the opportunity to come to a hearing, we need to flip that around. You need to state that, please come to a hearing, and if you don't, or you are found to be in violation, a $50 fine may be allocated to, or assessed to your account. We need to make sure we get the order right, because the courts are really looking at the covenant violation letters, and if the violation letter purports to assess the fine in any manner prior to the opportunity for a hearing, it'll invalidate the fine. It'll just throw it out. It's pretty specific that you have to give the opportunity first. Yes, sir?
Yeah, if we're going to assess a fine, for example, covenant violation, do our covenants or bylaws have to state that we can do that?
No, that's getting into, you have specific authority without it really even appearing in the declaration. So you can, your declaration does not necessarily have to say you can fine. Statute gives you that power. Yes, sir?
Do you happen to have a sample of like maybe a best practice notice letter that includes fine?
I do. Not on me. Before you leave, let me know and we'll send you a sample fine letter. Because we do. Yes?
It's that clear. So there's a violation.
Yes.
Violation notice is sent out.
Yes.
If there's no, by the documents, then the next notice, if there's no response to the first notice, the next notice imposes a fine. But if the first notice doesn't say you can have a hearing, even though the documents say that, and if the person looked, they see that they can. And so the second notice imposes a fine. Is that fine? No. The first notice doesn't tell them they can have a hearing.
Yes. The question is, if your declaration contains a procedure for finding covenant violations, and then fining or assessing the owner for the violation, your declaration is now probably contrary to what the Colorado Common Interest Ownership Act states, and you are required, every association is required to adopt a covenant enforcement policy. Your covenant enforcement policy, while it should be written in conformance with your declaration to the extent it can, must first offer the hearing before you can fine. So even if your declaration says, in the event of a violation, we're going to send out a notice, and then we're going to send out a fine letter if they don't fix it, what that really becomes is you send out a notice, and then the second letter is, and oh, by the way, if you don't come into compliance and or request a hearing, you will be fined. It's not automatic anymore. You can't have automatic fines. There is a procedural process now required by the legislature and the courts before you can assess any fines. And remember, it's an opportunity for a hearing. It's like if somebody blows off their court date. The court can assess the fine, but they had to give them the opportunity to have that hearing. And that's essentially what the legislature has done for an association. The declaration, or not the declaration, I'm sorry, the board of directors, through impartial decision makers, are now a tribunal, and you must have that opportunity for the hearing. You got a question, sir? Or you just, you okay, good. All right.
So
Yes,
it's
ma'am.
like a three-part process then. You're committing something, we could fine you, you need to request a hearing, or we will fine you, and then the third part is letting them know they've been fined, or do we have to let them know?
The question is it now like a three-part process? And in a way, yes. If you choose to have an initial warning letter, there's nothing in the statute that says you have to choose to give them an initial warning. You can go straight to your declaration and say yes, so you have to give them a warning. But there's nothing that states that you can't fire off the first letter saying, "Dear owner, you painted your house pink without approval, please change it, or you'll be fined after a notice and opportunity for a hearing," and you can come right out. You can start with the fine if that's what your policy says. There's nothing that says you have to give a warning, but you have to have the policy first. Yes. Yes.
Just so I'm perfectly clear,
Mm-hmm.
in the letter, before you impose the actual fine, you must state that they have the opportunity for a hearing.
Yes. You must state they have an opportunity for a hearing, and you can put parameters. If you fail to request a hearing within 10 days, it'll be deemed waived, or the board will, your hearing will be at the next board meeting, which is this day. If you don't show up, the board will find on the board will determine the existence of a violation based on the information it has. So I would still, at your next meeting, go through the process, whether they're there or not, saying violation number 1, owner painted their house pink without approval. Is there approval? No. And go ahead and levy the fine. Let me go back.
Oh, yeah,
Yes, sir.
go ahead.
Okay, so the process then is we send out a letter saying you have opportunity for a hearing, notify us within this time frame.
Mm-hmm.
The hearing, the next meeting would be, maybe we put in there a date. We come, they don't show up at the meeting,
Mhm.
we assess the fine at the meeting, we discuss it, assess the fine, and
That's it.
The way we do it right now is we have a courtesy notice.
Okay.
And I guess the way I took what you said is we could do the courtesy notice, put in there that you could be fined,
Mhm.
and mention the hearing.
Right.
We don't, the way I understood it is we don't have to provide information on what dates we're meeting or anything. It's up to them to call and request the hearing and ask, when can I come?
Right, but you need to give them, the question was, do you have to give them a set time or date for the hearing? And no, you can state, you must request the hearing within X number of days. But you do have to let them know how to request the hearing.
Oh, yeah.
Yes.
We have information where they can call and everything.
Yeah, there you go.
The thing is, if we have to put down dates on every notice we
No.
send out, oh my gosh, we're going to incur more fees from our property management company.
Oh, absolutely, and the question was, do you have to put all the dates? And that's why you can really, your notice should state that if you fail to request within 10 days of this notice, the board will determine the existence of a violation on the information it has. And that's really what you're doing. You're still having a hearing, whether they request it or not. They just won't be there, and you'll determine the existence of the violation based on the information you have. Yes, sir.
Well, if we don't have a meeting, say we're having meetings every 3 months, we have
Yes.
more frequent, but assuming hypothetically we have a meeting every 3 months.
Mhm.
In the beginning of that time frame, we go through the process, we notify a homeowner,
Mhm.
and says you have 10 days to notify us. They don't notify us, then this kicks in automatically. We don't have a meeting to discuss it. It kicks in. Is that okay?
You know, I would still ratify it at the next meeting because, again, you want to make sure that there's something in the meeting minutes that you discussed it and a fine or a violation actually did exist. Because my guess is you guys didn't actually see the violation. Your property manager did.
So the property management company
Yeah,
handles most of
maybe
that.
took a picture of it. So I mean, it existed. And the question, you got to make sure that they didn't. What if they got the letter, didn't request a hearing, but fixed the violation? So you need that kind of follow-up. You don't want to fine them if they fixed it, because the object of the fine is to obtain compliance. It's not to get their money.
And we have removed fines
Yeah.
Because there are some cases where they will get fined and they'll call and say, hey, I corrected it
Yeah.
last week. And
See, there you go.
somebody verified
But
it.
again, it's incumbent upon the owner to really request it and make sure. Yes, ma'am.
If a owner asks for, say everything is in order,
Mhm.
the owner comes and says, a resident, can you withdraw this fine? Because, yes, I did all that, but I'll never do it, whatever. the
Mhm.
resident. Can the board do that without setting a precedent?
The question is, can a board waive a fine without setting a precedent for all others? And your answer is no. If you're going to waive fines, you got a routine waiving of fines. And if that's really where, I mean, you could state in your policy, that if they missed the meeting or whatever and they came back or they corrected it and just failed to let you know, will you waive the fine? Yes. But to sit there and just blanketly, we'll waive fines if they come up and say, I'm really, really sorry, and then you don't waive it for the next guy. Then you get into the problem of arbitrary and capricious enforcement of your covenants. And that's, again, that's not what a reasonably prudent person would do. They uniformly enforce. So you don't want to get into a situation where you let one person go and not the next, and then maybe the third, because then it looks at, well, do you like these two and not this guy? Or, is it because of this? And it's just a road you don't want to go down.
So in a similar situation, when it's requested,
Mhm.
you have to have your own, the board has to have their own precedent.
Yeah.
You know they're setting.
And that's why you have to have a policy
So-
as to how you are going to do it.
So part of that, say you have a owner who is harassing and abusive over the phone to the management
Mhm.
accountant and, repeatedly.
Right.
And with repeated repetition of the
Mhm.
violation as well. And it's just how you sort that out, because that's more the case.
Well, but see, then again, you have a violation and a continued violation, and you offer notices and hearings, and if they fail to show up or they get to the hearing and you find a violation exists, you assess that fine. Now, you can always say in your policy that if they come into compliance, regardless of the fine, if they come into compliance within 60 days after, we're going to waive that fine. Fine, you can have that policy. But just make sure on day 61 you're assessing all the fines. So,
And
that's,
collect.
and take collection actions. Yes, ma'am.
So if you were, would you send this certified?
You're getting into, you send it however your documents say. If you are going to start sending certified mail out to everybody, but it also gets really costly. And it's not required unless your declaration requires it, or your bylaws. So, okay. Yes, ma'am.
We have a situation where in our rules and regulations that there's no dogs allowed.
Mm-hmm.
But somebody has a official caregiver dog. And so what we have done is request a letter from the doctor to certify that this person needs a dog
Mhm.
and da-da-da-da-da. Is that going to be enough for us to cover when we see the next dog come down the road that is probably not a certified caregiver dog?
The question goes to certified caregiving dogs, and seeing that's a whole nother 3-hour class, I'll answer it at the break. Yes.
Is there a maximum fine you can impose?
It has to be reasonable. The court, the question was, is there a maximum fine you can impose? It has to be reasonable. I have associations that I've recommended that we have a $1,000 fine for certain violations. There's a reason for it, though. This particular association has had issues with fires and fire damage, and we are aggressively attempting to combat that. So with that, in that situation, that fine may be perfectly reasonable. Whereas if you have somebody leaving their garbage cans out and you have a $3,000 fine, it's probably not reasonable. It's again, your fine is intended to obtain compliance, so it can be set at a level to obtain compliance, but not more, because the court will strike those down. Yes?
Do you differentiate between fines and late fees?
I don't differentiate. The question is, do we differentiate between fines and late fees? And I don't do it. The court does it. Late fees are put on notice already by the failure to pay assessments, and you send them a reminder letter. Fines are for violations where you should have an adjudicated hearing. Plus, remember that if you're trying to collect late fees, you may be in court anyway, and that's going to be their due process, is when they're in court. So, let me see. You have the power to indemnify officers, which everybody in this room should be really going rah-rah, because you will be indemnified for acting as a board member so long as you do everything I've said to do. So, it's my impression, my feeling, is that you should indemnify for everything but gross negligence, bad faith. Because you're never going to get anybody to serve on the board if they're going to have to worry about personal liability in negligent situations or personal liability. And I highly recommend in the association context, the association just indemnify across the board.
$1 million, $2 million?
Oh, that'll be, you indemnify for whatever their actual costs are in their defense. And let me take a step back. Let me get this question, and we'll come back to yours.
Can you indemnify agents that are working on behalf of the board?
You can, the question is, can you indemnify agents? Yes, you can indemnify agents. Most of your contracts probably, most management contracts probably require it. And getting back to, I want to make sure we know exactly what indemnity is. Indemnity is where, in the event the association gets sued, and for some reason they name board members personally, the association picks up the tab or reimburses the board member for their defense of that lawsuit. That's the indemnity, to make sure that there's no out-of-pocket expenses on behalf of the board member in their capacity, while acting in their capacity as a board member. And that's what indemnity is. I just want to make sure, based on your question, I'll make sure we cleared that up. And you have the power to indemnify the association. It's going to be in your articles and your bylaws.
Okay.
And you also have the power to charge use fees for amenities within the community. Let's say you have a pool, and let's say your declaration doesn't specifically prohibit it, but you want the pool to be, for lack of a better term, self-sustaining. You can charge use fees for the use of the pool or the clubhouse to offset the cost of maintaining the facility. Let's say only 80% of the, let's say only 75% of the community uses the pool, 25% doesn't. If you wanted to go down that path, you could charge use fees to those 75% of the owners to offset the cost of the pool, because they're the ones benefiting from it, at least the use-wise. Everybody benefits from the pool by the fact that it exists and it improves property values. So I wouldn't try and charge all of them, but you can offset the cost by charging use fees. There are some associations that have trails. They can charge use fees for trails. You can charge use fees for pools, trails, any of those other kind of extra amenities that are above and beyond. I wouldn't try and charge, excuse me? Volleyball courts, if you've got those. I wouldn't try and charge use fees for parking. Elevators, it's frowned upon. But you do have that ability to charge use fees if you have a specific amenity. And most people know, most people do this when they rent out their clubhouse. If you have a clubhouse and somebody wants to have a graduation party, you can charge a fee for that graduation party or for the renting of the clubhouse.